Hello and welcome. Thank you for watching our presentation today. The law offices of McLaughlin & Associates and McLaughlin Mediation and Consulting focus on helping small to mid-sized businesses grow and thrive. You started your business because of your passion. Let us help you with that vision. We offer a variety of legal and human resources services. Check out our website for more details at www.ma-lawpc.com. And now, on to our presentation.
Good morning. My name is Ken McLaughlin. I know I've met everyone here, and I want to thank you guys for coming to this presentation. This is one of our biggest areas of our practice, which is employment law. And we do employment transactional work. Carrie does our human resources, but then employment litigation. And unfortunately, it's unavoidable, whether you have one employee, if you have 1,000 employees. I mean, everybody has the same issues. And in Illinois in particular, it only takes one a lot of times for you to have liability. And so the 3 areas we're going to have is going to be federal and state employment laws. There are some similarities, some differences. The discovery process in employment cases, it's not the lawsuit that's your problem, it's that discovery part. And then settlement conferences and mediation, the difference between how you settle cases when a case goes to court and how you can mediate that. So the way that I kind of look at this is, so we just went on vacation to Orlando. And so you know when you go, you're really looking forward to the rides until you get on them and it went up just a little bit faster than you wanted it to. It's kind of like that. So at a distance, things look one way, and then when you get onto the roller coaster, it goes really fast and it's out of control, okay? And that's kind of how employment is that when you're in the middle, when you hire people, you feel like you have control over it. And once someone sues you, your emotions get involved, it takes resources, it takes time, and then everything is out of control. And it's not fun, right? It looks fun from a distance and you feel like you're ready for it, and then you get into it and it wears you down and it's incredibly expensive. So that's why we're doing this, is to talk about recognizing that that is the process. What can we do kind of on our end to protect that? All right, so the very first thing is, you guys know this is, we're an employment at will state. Now, if I were to present this 10 years ago, I would say categorically we're an employment at will state. If you ask me today, we are closer to an employment, a right to work state, okay? The difference between employment at will and right to work is, in employment at will, you have no right to your job and you have no right to your employee. So an employee can quit for any reason, no notice. An employer can fire for any reason. And that's why I have this little cartoon here, which I thought was funny. So, little Dilberty cartoon. I have a bad feeling about the direction of my project. You complain too much about nothing, you're fired, right? That's standard employment at will, right? No one has any obligations to anybody else, okay? The important thing to know about employment at will state is severance is actually completely optional, all right? You don't have to do, you have no courtesies have to be extended either way. So the employee doesn't need to tell you they're looking for a job. They don't need to give you kind of notice. They don't have to make you feel good about your job. They don't have to be pleasant, but it goes the other way as well, okay? You don't have to give any kind of money. You don't have to give them any notice. You could literally have them come in good faith. 5 minutes before they're ready to leave for the day, you're like, here, get out, your box is over. That's completely legal. Now, for obvious reasons, we don't handle things that way. There's an unprofessionalism to that, but just know that that is in fact the case. The only exception is going to be under the Illinois and the Federal Warrant Acts, 75 at the Illinois level and 100 at the federal level. So large employers, that is a problem. So when they're doing, usually you'll see that like the mass layoffs in like a factory setting or like an office setting, you know. So that is a real thing. But for most small to mid-sized employers, they don't hit those numbers. They don't have people, they don't have stable employees throughout the year. That would be that number. But that would be your exception to the rule. Okay, so terminations, I just want to kind of highlight this. So we have the printouts for a reason, and a couple of the slides here, there's actually 2 of them, but there's only one here, so everything's condensed, but so that you could see it, just so you don't get confused. So there'll be a couple slides that's like 2 or 3 versions of the same thing. So the documentation is extremely important, okay? So I'm just going to kind of go through these. The job description, you don't have to have it, but it's important. So the more technical, or like a sales role or a technical role, and I think about, in a hospital setting, a medical setting, you think about a situation, an engineering setting where they have to do finite things. If you don't define them, how can you say that they didn't know what they were doing, okay? So that's the important thing, all right? So then performance evaluations, again, that's a double-edged sword. You don't have to have performance evaluations. We do them on an annual basis because people expect it. It's kind of a personal way to get involved. Don't feel like you have to go overboard to be overly critical or overly nice. I think I would use it as just a tool to let people know where they are. So if you have problems, identify the problems. If they're doing a great job, same way. Also get some feedback. So write-ups, and make sure, so you have verbal warnings. Now I'm going to talk a little bit very quickly about the unemployment process in a moment, but verbal warnings are no warnings whatsoever. They will be forgotten, they will be denied, and stuff like that. So use a verbal warning for somebody that you don't want to warn. In other words, that's kind of like you bring them in, you're like, hey, I need you to just make some changes here. Use a written warning when you're actually trying to log. So if you have somebody that you're considering terminating or they're a problem, make sure it's written. If you're just trying to say, you know, you're a little sloppy here, something like that, then just, that's the kind of things that you don't need to rely upon. Email documentation is important. So if you send emails, make sure that you have a system that can retain them. It's usually better, just to print them out and keep them with your folder for them. It's that very next point, it's that notes of investigation. So in particular where you have a problem, yeah, your own internal notes matter. When we talk about litigation, those are all discoverable, so you got to be careful how you write them, right? You don't want to write it in such a way that you actually look like you completely messed up. But factually setting forth that is important, especially, again, let's say that you have a situation where there's a license involved, and someone, if they do certain wrong things, that's going to be a problem. That's a double-edged sword. You don't want there to be written documentation and you can now be reported, right? And you're like, oh, well, you as an employer, you know that you have violations. But on the other hand, you don't want a person saying, well, you never told me this, okay? So there's kind of a fine line, but yes, definitely factually keeping a log of a conversation that took place that's significant, I would do that. The employee handbook. So that would be a topic for a whole seminar in and of itself. Employee handbooks are not required, but they're very helpful. Why are they helpful? It's for setting forth your standards, okay? That's why you have them. So your policies with respect to time off, your respect, you know, do I have to show up on time? You know, what happens if I have leave time? You know, there's bereavement leave, all those types of things. The law requires certain minimums. Sometimes it doesn't require anything, but you are stuck with your policy. So that, again, you want your employees to know where you stand. And really it's helpful in the beginning, because if someone comes to work for you, their work ethic matters, right? There's some people who, they want to come to work and work minimally. There's other people who are going to be your superstars, and most everybody else is in the middle. So you need to have some consistency, which we're going to talk about in a little bit, which is inconsistencies, especially with the employment handbook, can kind of go against you, okay? So you want to make sure that that's good. And so the last one, obviously a little self-serving, which would be, you know, you rely upon professional advice. So legal counsel, having independent reviews. A lot of times insurance companies will help out with those types of things, like your ADPs and that, they will have resources that you can go to. And then internally, so if you know, everyone, if you don't have an HR manager, which for a small employer you wouldn't, but the office manager often would have the role of making sure that that's there and having that interaction with the professionals just to make sure you have those in place. There we go. All right, so I'm going to go through some of these laws. I'm going to blow through them. Some of them I'm going to slow down. And so I'm slowing down on some of them because I think they're really important. Some of these I want you to be aware, it's all in your notes. But if there's something you're like, I want you to spend a little bit more time, that's okay, I can do that, okay? So this ban the box is relatively new. It applies to the smallest of employers. And it has to do with the application process. So it's what you can't ask in an interview. Way back when, really not so way back when, you used to be able to ask people about their honesty, their felony convictions, and frankly, even drug use in a lot of situations. You can imagine like trucking companies, that kind of stuff. You don't need somebody on the road who's high. But unfortunately, you know, with the laws being such change now, it seems like everything is legal, you know, from an employee standpoint, and then the employer somehow has to kind of fix the world, right? And this is one of those ones that's going to feel that way. So you're going to be in the interview process. You're not going to be able to ask certain things about people's felonies and those types of things. And then all of a sudden it's going to be disclosed to you and you're like, what do I do? Okay. So here's what you want to do is that very last one right here, right? This point right here, that's it. It's the job relatedness of it. If it's reasonably job related, you can ask about it. If you have a question, you just ask someone like me and then we walk through it. I do that a lot. So honesty, if someone's your bookkeeper and they had a felony conviction for theft, that's relevant. You have every right in the world to ask that. If you have somebody who's going to come in and they're going to work in the warehouse and they're just stacking boxes, their felony conviction for theft probably doesn't matter, right? Although you would say, well, they're going to steal stuff out of the warehouse. But again, weirdly enough, it becomes a gray area. So again, just know that this exists. You have to be careful about what you ask. And in a difficult situation, sometimes just 15-minute call, just kind of bouncing off some things. And then it's funny because if you're asking the question, they're probably not worth it. You're probably more desperate for an employee than you are actually hiring that person. So a lot of times you just say, just don't bother. The employment laws, again, we've done other presentations on this, so I just want to kind of reacclimate you to it. So as you probably know by now, obviously minimum wage is $13 an hour. It's going up to $15 an hour. There was a time at which there was such a discrepancy between minimum wage and regular salaries that no one had an issue. But now we're getting these points. You have your lowest level people, your office workers. It becomes very difficult to employ. It's funny, we have like this double-edged sword. We have on the one end, the wages are going up, making it very hard to be profitable. But at the same time, you have people not wanting to work. So the two are coming together. It's almost like the minimum wage isn't even good enough anymore. So, but anyway, that's what it is. The overtime thing to keep in mind, it's over 40 hours. So if you have somebody who worked 20 hours and then you had them working like 8 hours, and then at the very end you had them working 40 hours at the week. So they did 40 hours in like say 3 days. They're not owed overtime. They're not owed anything over 8 hours in a day. Okay, so that's where people get confused. The other side of it is you can't say 80 hours in 2 weeks. Okay, so that's sometimes you'll see these mistakes where people will say, well, they only worked 30 hours this week, they worked 50 in another, or say they worked 55, and they're working 85 hours, but it's spread out, and so I don't have to pay it. And that's not true. It's going to be on a per week basis. So you could be under in 1 week, and then you could be over in the other. So that's the important. That's right, exactly. So Illinois, which is what, for when it comes to minimum wage, that's all that really matters, because other states, you just deal with them. The 1 day in rest, just to kind of let you know, so you have to give people off 1 day in 7. There are waiver rules, so I know there are people who work 7 days a week, so there's ways to get around that. You actually have to have them sign something that basically says that they understand they have a right, but they waive it. And then the second thing has to do with the meal periods. Strangely, this actually is violated quite a bit, where people don't even give people 20 minutes for lunch. And it's not their bathroom break. So a lot of times people will say, like, oh, you went to the bathroom and you're there for a half hour, and I think you were playing on your phone, which is probably not untrue. But the bathroom break is the bathroom break, okay? Now, if they're constantly going to the bathroom break, what do you have? You have a worker who's not working. It's not this law being violated. It's you as an employer having to say, you're not doing your job, okay?
Did that law used to be 5.5 hours after?
I think it did at one point. Yeah, it's varied over time. And it's funny, the 20 minutes it seems really light to me. I mean, I don't see how anybody can go reasonably to a lunch. I mean, we give an hour, and we don't even make it unpaid. We just make it paid, because how are you going to monitor that? But I know in restaurants it's a different situation. So each employer has to kind of decide it.
But common practice is 30 minutes for the hourly employees.
Yeah, exactly. I mean, I think there's a standard.
2 breaks or 15-minute breaks that compensate an hour, and
Right.
for the salaried employee they take 1 hour lunch.
Right.
That's how companies compensate.
Yeah, I would agree. And so the 20 is there. It's really just a minimum standard. It's like minimum wage. I mean, if you're violating it, then you're violating it, and they want to make sure that they got that group of people that they can deal with. I also spent, again, independent contractors on another presentation. I spent time on that. I'm just going to very quickly explain this. So if you're hiring independent contractors, there's a couple things I want you to be aware of. It does apply to even the smallest employers with one. There's what's called an ABC test. So all of those agencies are interrelated, and if you violate one of them, all of them will come and audit you. That's what you need to understand. So you have the Department of Labor, which has to do with your wages. Employment Security has to do with unemployment. Department of Revenue has to do with payroll taxes, and then the Workers' Compensation Commission has to do with workers' comp. The smallest case will trigger this. What I'm saying is that your worst employee that you only paid like $2,000 because they only worked for you for a small period of time is the person who will report you, and they will trigger it. And they cost, you almost have to pay them. I had one that just literally came across with them. They were like, they wanted $3,000. And they said, well, we didn't employ them. I said, I understand that. I said, pay it anyway. Why? Because it's just closed the book on it. You don't want to mess around, because once you raise the question about their employment status, some auditor will get involved, and they have to make sure you're correct. And because they have fiduciary duties to the state, they have to do these like intense investigations, and then you end up spending more time. So just be aware how interrelated those things are. Okay, construction industry, and no one here is in the construction industry, are they? Okay, so this is really why there were problems. About 20 years ago, they cracked down on them because independent contractor status is horrible, even today and that. So that's a big deal. So the ABC test, it comes out of the Unemployment Act. So it's basically control essential services and independent business. So the A test is control. So if you're controlling what they do, pretty much they're going to be your employee, because you have to satisfy all three of these elements, okay? So I have this laundry list here of the ability to hire and fire and setting what pay rate and those types of things. Use common sense. Literally, if you control what they do and you control their rate of pay, and really it's your customers, they're your employee. I mean, everything else is just kind of icing on the cake. The B test is essential services. Can you do your business without them, okay? So, if I'm a medical office and I have nurses working for me, are they independent contractors? They are not, right? They can't be or can't do that. However, if I have a specialist, so what if I'm a chiropractic office and I have a massage therapist? Or if I have somebody who's doing something else, sometimes they can be, because I don't have to be a chiropractor because it's a different license than a massage therapist. So that's what you want to think about. Again, if you're in a gray area, better to kind of discuss that. And the issue about reporting in. So with remote work, it became very questionable. There used to be a situation where people would say, well, they don't have to come to the office, therefore they're independent contractors. But then so many businesses now, they don't have to come in. So really where they're physically located is not really a factor anymore. I mean, if they're working for you in an essential business, that's what they are. And then the C test is, are they an independent business? So I had an opportunity to speak to an auditor about this years ago where I had a case. I'm not joking, they had everything done by the book right. We had contracts, we had tool agreements, we had recognition, we had everything that was supposed to be done where someone was an independent contractor, except for one factor. They didn't incorporate their business. And the auditor said, all you have to do is tell your businesses to incorporate and they're going to be fine. I don't think that's even the standard anymore. I think even that they would come after you, but that's the minimum. Here's what happens. Someone will want to be on an independent contractor status. Sometimes the employee actually wants that. Many times the employer does. But no one wants to pay the couple $100s to incorporate because it's too much of a problem. And it blows it open because you're paying somebody through their social security number for services that are arguably part of your business. They're not independent. And especially when you factor in, it's like, well, what percentage of your pay is coming through this place? 80%. Okay, what about the other 20%? This is actually a real world story. I'm delivering pizza on the side. Can you live on delivering pizza? No. You see, so again, if they're not a truly independent business where they're selling their services to someone else, they're not going to be independent. Okay. Fair Labor Standards Act has these 7 factors that they look at for, and this is it. In recent time, and I don't have that slide here, I talked about it at another presentation, but there was a debate between then President Trump and President Biden about what, these different standards. They were carving up these 7 factors, and they were trying, on the one side it was trying to make it more difficult because it was pro-employer, the other was trying to make it more, easy because it was going to be pro-employee. But honestly, they were all permutations of this. So it's basically, this is the standard. You want to, if you look at those 7 factors, and if you're complying with them, fine. You don't have to comply with every single one of them, but the closer you can to perfection, the better. Okay, now we're going to get into the heart of what we're going to discuss, which is all these different employment rights. Employment discrimination, probably the number one thing you're going to deal with. So at the federal level, it's 15 plus employees. Now there's always a question that people have is like, what does 15 employees mean? 15 employees means 15 employees. It means your part-timers and your full-timers. Some laws have situations where they will talk about part-time equivalents, or full-time equivalents and that type of thing. This is not going to be one of those, okay? And it's so broad-based. So the federal law, it has race, color, the ones that we're used to, religion, national origin, and pregnancy. Those aren't a surprise. It's the gender one that's become the issue, and it's because of the transgender issue. It is an issue. If you have someone transgender in your office, you will have to deal with it. And this is the federal. The state is far, far more generous, okay? Because it has a sexual orientation provision in it. So you can't avoid it, okay? It's something you're going to have to deal with. What you're really going to be stuck with is Can they do the essential parts of the job? If they can do the essential parts of the job, it becomes a non-factor. You have to think in the way we would think about men and women, earlier. And it's unfortunately become very complicated, but it is what it is. Now, the thing I want you to keep in mind is this point right here: owner's personal liability. You can be personally liable in this law if you know what's going on. Okay. That usually is a situation where the manager or supervisor is directly involved, or the owner excuses the behavior of the manager and actually short circuits the investigation or turns a blind eye. Restaurant situations, it happens a lot. I would say that the more professional the office, it's less likely because you really can't get away with that. But just be aware that is a risk. So when you have a situation where someone makes a complaint, you have to fully investigate it, and if the manager is involved in it in any way, and if the owner is implicated, then it has to step apart. Better way to do it is you actually hire outside counsel, or someone like us, we come in and we do the investigation for you. It becomes privileged, but then you get a true opinion. Attorney opinions do help you, but they're not foolproof, okay? So the more neutral it can appear, the better. But if an owner or a manager is directly involved, they're not gonna be saved by that corporate shield. And then this at the bottom, mandatory sexual harassment training is a thing now. It's not too hard. It's just a module that you can get. We offer it, but then there's a lot of services that do it for relatively inexpensively, but just making sure you're doing the mandatory sexual harassment training.
Is that required for all employees?
It's everybody, yeah. And it's even for one. I think it's unreasonable. I mean, my personal opinion, it gets a little unreasonable because if I'm working with one person, I mean, it can happen, right? I mean, obviously sexual harassment can happen with one. It's just, I think what they don't want to do is they don't want to get caught in this web where they have transient employees going on and suddenly they're like, well, I only have 2 employees in that. They just feel like this is a zero tolerance. And so, and it's not hard to do. I think it's also because of the modules. I think the maximum price that you can get online is maybe $300 or $400. I don't think it's overly expensive.
We have bundles with some.
I'm certain ADP probably does, or your payroll service, So then the employer defined, oops, sorry about that, went to my wrong slide. This right here, just at the bottom, I wanted you guys to know that how they define it. So 15 employees, they have to be working 20 calendar weeks in the year. So somebody that you hired for a week or 2, you don't have that issue. They have to have been there for a period of time. Americans with disabilities, over here, same thing, 15 plus employees. This is a tricky one because of kind of this definition here of disability. It says physical or mental impairment that substantially limits one or more major life activities. And now the key thing is they have to bring it to your attention. You don't have to be, come junior doctor to figure it out. But that limitation can be mental, it can be physical, and a lot of times it is mental. I mean, I think the hardest ones that I've seen would be the ones where they don't have the concentrations there. Let's say that somebody has ADD or something like that, where they have difficulty sitting for a period of time, as opposed to the person who's got a back issue and they have to get up and walk. And they have to come to you and say, here's the situation. It's one of those situations where medical actually does freely get talked about, but they have to tell you what they need. The only time that you really can get away with not doing it is if basically they can either perform their duties without any kind of an accommodation, or they just can't perform the job at all. So and that's usually not the case. Like I said, usually it's a situation where you either have a helper for somebody who has to lift something heavy, or again, the concentration doesn't seem as big a deal because you can always get up and allow someone every 45 minutes to get up and kind of clear their head. But you also run into problems, and we're not talking about this one today, but imagine a situation where they're taking multiple days off of work and now you have to terminate them for losing work. That's where the documentation comes into play, and it happens quite often where someone can miss as many as 15, 20 days in a year, and your policy is you can miss 5. And you just have to monitor that very closely. You probably are, unfortunately, in a situation where you're at risk for one of these types of claims dealing with Americans with disabilities. But the better way that you can document that, the best you can be, and just try to be a decent employer, meaning that you kind of having somebody who can interact with the person and make sure you can kind of keep temperatures down a little bit. So everybody has some type of a leave policy, right? You can take so many sick days, or you have a PTO policy, or you have somewhere where maybe you give everybody a week or whatever that is. Now you have the person, though, because of their particular position or their particular situation, they're going like 3 or 4 weeks off. They violated every policy, but you're afraid that because you aren't going to give them the time, you're going to get sued. And that's the consistency thing. I mean, at some point in time, you do have to draw a line in the sand. You have to say, you have only so much time to work here. Are you able to do the job with the accommodations? And at some point in time, the true answer is either they can't do the accommodation or they don't want to do the job, okay? And that's where really kind of take off that HR hat and as a human being, you sit down with the person and say, what's going on in your life? Sometimes the better thing is the person to move on. You transition to the next part of their life, but sometimes you do have to make the hard decision from a business owner. You're like, look, I have to let you go because you're disrupting everyone else. You have to think about morale issues in particular, right? One person's taking off all kinds of time, everybody else is kind of busting their hump, and they're like, well, why not me? Well, eventually everybody's going to take it off and then it kind of goes open. Is there a solution to that? No, because we deal with that every day, but at least we could tell you what the laws are. So we have age discrimination. For some reason, it's a little bit different. You have 20 employees. We don't get a lot of age discrimination cases because usually people are, it's retirement, those types of things, but it can happen. What would happen is if you bring in a manager at a high level and all of a sudden you get rid of the person because they're starting to make too much money, you start bringing in younger people. It'd have to be pretty egregious, so that would be the situation. It's funny, these days actually there's more older workers than younger workers because of just kind of the way the demographics of the workforce are, so it's not even an issue. Pregnancy discrimination, I think that's pretty straightforward, right? If you have a pregnant employee, you have to give them time. You can't have a situation where suddenly their job disappears. That used to happen. Actually, earlier in my career, I had a couple cases where people strategized to get rid of people's jobs because they were pregnant. I think that the culture has changed where we don't view that as a negative, but we've all been at a point where we know that was a true issue that people dealt with. Okay, Illinois human rights. So this is your difference. You have 15 employees. Okay, that's the same. So for all of these areas here, okay, but not these here. So disability and sexual harassment. Those are your top two ones that you're going to have. So again, that's with the discrimination. And with the sexual harassment, this right here, the sexual orientation, which is unique to Illinois, these days that's going to go into sexual harassment. If you single somebody out because of their orientation, it's going to fall under that type of harassment. So again, we might as well just go with a one employee standard because that's what you're going to be dealing with. Okay, Family Medical Leave Act. So this for small employers is never going to apply. It's 50 plus employees. Plus they have to work 1,250 hours in the past 12 months. So part-timers a lot of times will fall under that threshold. So you have to give them the 12 weeks. You can require them to use their PTO and medical benefits. It applies to their immediate family. So is anybody at this level? No one has 50 employees here, do they? And then we have the Military Leave Act. Again, it's not really a big deal. A lot of people aren't in the military. I mean, it's just the kind of time we're in. But again, just so you're aware of this law, that it exists, that there's a military leave policy in place. Okay. That's 15 to 20, yeah. So that's why we have it. That's why I have it in the yellow, so you can see the different numbers. Unfortunately, got to do a little math, but I just wanted to point these out. I'm not going to spend pardon me?
Sorry.
Oh no, I'm not going to spend a lot of time on these. I just want you to know about these are my other employment laws. So you have here this the Pregnancy Workers Fairness Act, which is sort of the state equivalent of ADA, and then you have this Pump Act. Again, these all, in my opinion, some of these seem to should have been under the broader acts and just been additional things, but they make them independent laws, which I think makes it harder for an employer to actually monitor. Because if we had a law that said, for example, a sexual harassment policy that defined it more broadly and just said, this is your standard, it would be easier to follow. But if you have this law and now you have brand new law and you have brand new law, now you're always looking over your shoulder saying, well, what is the new law? And I think that this law here is one of those. I don't know why that couldn't have gone under pregnancy discrimination, because, right, if you're a mother, that's the way it is. And that is an issue. I mean, these things have happened. I know, Carrie, way back when she worked in corporate America. I mean, that was a number one thing, right? That would happen all the time. Well, you guys, everybody knows that, right? Okay, so then the ADA, just a couple things. Reasonable accommodation, which I touched on a minute ago. So it says ADA does not protect employees who cannot adequately perform the job duties and were discharged for poor performance, but not because of their disability. And then FMLA and the Pregnancy Discrimination Act kind of closely go together, so one will trigger the other. This is hard to prove on our end. On the employer side, that's super hard to prove. That's why documentation matters. And I hope your documentation was in place before they told you about their disability. If they suddenly have poor performance issues after disability, you all but bought that lawsuit, right? Now, what's interesting is sometimes someone has a disability that causes poor performance. You know, there is a cause and effect there where a person was a great employee, and let's say that someone was involved in an automobile accident and there was a concussion that came from that, and now they were always able to be on top of it, and now they can't, you know, because they have the after effects of a concussion. Okay, you have to recognize that that's a thing, right? I mean, those things occur, and if their performance issues change, that's when you want to get into the accommodations. What do you need? I can do my job, but you remember I used to sit at the computer screen for 3 hours? I can't do that anymore. That's okay. What can we do? You know, I just got into the auto accident. I used to be perfect. I used to be able to lift like a monster, you know, but now my back, I can't do that. Okay, what do you need to do? You know, I know you had a physical job. Can we move you to another role?
But we follow the doctor's instructions on that situation, right?
You do. So early in my career, I used to do workers' comp, and the issue was that the doctor's orders are always going to be harsher than the employer thinks is reasonable because they're helping out their employee. They're never going to give an advice on it that says that they can do just exactly the right amount. You know, like the doctor's not going to be neutrally and saying, well, I think that realistically in my mind they could go 50 pounds. No, they're going to say safely they can do 15 pounds, and you're going to be stuck with 15 pounds. So you're right, following that. But a lot of times what will happen is, and I saw this in workers' comp in particular, where the insurance company in particular would say, we don't agree with this. They get their own doctor, which is their independent medical examiner, who's paid to basically say something else. And then the employer is stuck, listening to their workers' comp carrier, not to the doctor. Because now they're stuck. They're like, well, they're telling me they should deny it. And now you're saying, well, wait a minute, if you screw around with the Workers' Comp Act, are they now going to, you know, are they going to quit and then they're going to sue me because of employment violations? There's all kinds of, it starts snowballing. And so one of the things that we used to have to worry about in defense is we'd always anticipate the workers' comp case that would go south. We'd see how aggressive an insurance company would be. And the next case that we'd be defending without insurance was an employment liability case. And so just, you know, so it is what it is. Okay, so retaliatory discharge. See, here we go, right on time. It's almost like we prepared that, right? All right. So it is the exception to the employment at will situation. All right. Now, what's going to trigger it is violation of the laws I just told you about. If you do, and I want to go, and in my next slide is I'm going to tell you kind of what your threshold deadline is going to be. So what happens is that if someone's your employee and then they file some kind of a claim, and I don't mean even a formal claim, but they've suddenly brought a disability thing to you and you fire them because of poor performance, you're going to get this. You're going to get a retaliatory discharge claim. Or if they filed a claim and now you countersue them for almost anything. So imagine that you fired them because they stole from you, and now they filed a claim against you. Now you counterclaim against them for the theft. That's retaliatory. It's not, but unfortunately you have to deal with it, okay? So what happens is you're stuck. Once that person brings a claim, you got to be really, really careful about how you handle it, okay? And then if your employer reported you for any illegal or improper conduct, it's retaliatory. That means just if they call up OSHA for any kind of a violation, they call up, I'm concerned about these practices going on. They call up IDFPR, hello, I think I have an issue here. Those become what are called QUITAM, QUITAM litigation. Those are your whistleblower type cases where the person in the inside is helping the public and there are attorneys waiting to take those cases. And those cases are expensive, even if you're completely free from wrongdoing. So this is the last thing you want to do. Don't fire people, like don't knee-jerk react and say they're done. You know, there's a time and a place and there's a way to do it, okay? So here's your standard. The employee must show that they were engaged in a protected activity, not going to be hard when they got discriminated against. The employer took adverse employment action, fired them. And the third is it caused the adverse employment action, okay? So the other thing I didn't mention is in addition to firing, it would be, for example, reducing their pay, reducing their hours. I've seen that happen where suddenly someone was working full time, all of a sudden they don't need them, they need them 20 hours. That's a problem. So you have to establish some valid pretext, a valid reason that's not a pretext. So if the first time you complained about their behavior is after they reported it, it's pretext. It's necessarily, because if you didn't have a problem with them before, how did suddenly that happen? And you'd be like, well, they were a different person before or anything along those lines, but it doesn't matter. The law doesn't look at it that way. The law always gives the benefit of the doubt to the employee. Okay? Now here's what I want you to think. This 1 year, you do anything within a year of them filing suit or making a claim, it's per se retaliatory. You will not win that case, ever. Okay? Now, if they worked for you and they brought a claim, and now, I'll just go back to kind of the workers' comp situation. Someone worked for you, they were on comp, and now we're like 3 or 4 years after the claim. The fact that they at some point in the past filed a claim, that's not going to hurt you. But if it's in that short 1 year period, you can sometimes get around it, but almost never. All right. So now termination and unemployment benefits. So this is a little bit different. Again, I'm not going to spend too much time on it. I just want you to be aware of. Its misconduct is really the way that you get away from paying unemployment benefits, but poor performance is not misconduct. So misconduct means misconduct. It means screaming at a client. It means stealing from you. It means refusing to work. I don't mean having a debate with you about something not being your job, okay? It is insubordination, but not like this. I mean, you have the discussion with them, you explain the way it is, and they said, I'm not doing that job. I don't care what. You fire them. That's misconduct. I will tell you that there's issues that I've had where an employee has violated licensing standards. I had a case involving a pharmacy. And the pharmacist, we believe that they were actually dispensing illegally pills to a certain patient. The unemployment office found against the employer, notwithstanding that violation, because the person didn't understand. They, in good faith, thought they were helping out the patient. That boggled my mind. I don't even understand how that was, because I said, per se, this is the way it's supposed to be. The person is a licensed pharmacist. This is the law. You just have to know that it's sometimes a crapshoot on who you're going to get as your referee. And that's how broad the law is, that if they don't think it's misconduct, if it's a mistake, right, here we have this poor performance situation, you're going to lose that case. I would still fight that case, but you just have to know about that, okay? So that's what I was talking about here, theft or felonious acts, unless it's a mistake. So I've had some crazy cases. Repeated missing work or tardiness, it's got to be documented. So the fact that someone missed 20 days and you talked to them but you didn't document it, and now you fire them, if there's no written warning, you lose that case. You have to give them written warning, okay? So just at this bottom point here, normally failure to warn or waiting before the termination causes the employer to lose the case. So he's got to be super careful about that one. And I want to make one other comment. Same thing with the investigations. So in discrimination cases, waiting is good because you have to have a thorough investigation. When it comes to unemployment issues, with like tardiness and those types of things, you have to act immediately. So you really can't, you have to say, you're warned, if you do X, you're going to get fired, and then you got to fire them. If you don't, you have to give them another warning. So you've just kind of compounded your problem. And if you're hard pressed for work, which a lot of us are, that's where that one-on-one discussion about how harsh do you want to be. If you need them to keep working for you, then sometimes it's just sort of a hand-holding, and I need you guys to figure out, like, we need you here for these reasons, and then you just make a business decision. Okay. So Wage Payment Collection Act, again, just very briefly, you got to pay final pay at the end of their pay or the next pay period. Okay, you can't wait around. I don't care what the reason is. They owed me this. They cost me this client. It does not matter. You got to pay that next check. Don't withhold it. You're angry because they just sued you for discrimination. You were the best employer ever. I was trying to help them out. I had situations where people were banking money for people for winter hours so that they would have extra money. Well, yeah, well, I just helped them out. It doesn't matter. You have to pay them 100% of what they're owed. But they owe me money back. I said, you don't get that money back. You're never going to get it. Why? Because when you sue them for the money you got back, what did we pick up? A retaliatory discharge case. So you can't violate those practices, all right? Or otherwise it's just the way it goes. So we cover some of the other ones here. So this thing at the bottom again is the personally liable. So Under wage payments in particular, you're liable for intentional violations. And again, it's a big situation with minimum wage where people would underpay them. The most egregious violation I ever saw, where I worked at a country club when I was in college, and people were living there not being paid. And you had immigration issues and a bunch of other things. So, no one in this room obviously is going to have those issues. But I'm saying that those situations do exist, and that's why this personal liability is if someone does that. Yeah.
Contractually, can you write into, let's say, your employee handbook or, somewhere that commissions won't be paid once an employee is terminated?
You can.
Or do you leave the quit for whatever reason separate?
Yeah, that's a good question. So with commissions, it's contractual, okay? If you didn't have a contract, the commissions have to be paid because it becomes a form of compensation. So the law has a very per se rule. It says, absent anything else, you got to pay it this time. When you have a salesperson in particular, or a contract where it says your bonus and your commission will be paid on a certain day or under certain conditions, it's not due yet, so you don't have to pay it. That's how that gets dealt with. So if someone has a commission that is due only after you receive the payment from the customer, as an example, or you have a waiting period because there's chargebacks or something like that, or you have a situation with a bonus, it's discretionary at the end of the year based upon certain goals, and you're mid-year and you don't know. All of those can be delayed because, again, by the terms of the contract, it's not due yet. The key thing is my compensation due when I quit, okay? If my compensation was due on my next paycheck, it's got to be paid. And I'll tell you another thing you can't do. You can't withhold the pay because they haven't signed a severance agreement. Okay? There cannot be a condition. You've got to pay them what's due and owing to them. And then, let's say you're paying them some additional compensation, you square up, as it were, at the end of the day, right? So if you've paid them half of it in effect, and they're getting another part, maybe the final payment is smaller, but don't withhold it because you just bought another problem. So now I've finished kind of the law side. Before I jump into this next part, does anybody have any question about any of those laws? And I really appreciate your questions because it really helps flesh things out. And you can see there's these little nuances in every single law. And understanding the law is important, but what I'm about to jump into is actually what you kind of need to know that you'd never think about. But does anybody have any questions about any particular law that we just covered? Okay, cool. All right, so the discovery process. So discovery is the work done in the legal process where you get information. So the formal terms are interrogatories and a request to produce. You don't have to remember those terms, but just know that those two documents are how we get the names of witnesses and how we know sort of what the claims are and what potential documents are out there, okay? When we get the documents, we can either do them through a direct request to a party, and they have to produce them, or we do them through subpoenas, okay? A subpoena goes to somebody who's not a party to a lawsuit. What happens many times is people naively believe that they control the flow of information. They believe that if they just don't tell their attorney, if they just don't tell the other side, no one's ever going to know, and they don't understand the subpoena power. So lies happen in every single case I have. All my litigation is commercial, all of it. Everybody lies in every case that I have. My own clients, I don't want to say my clients lie, but I'm saying they don't want certain things to be known, okay? That's just inherent in the litigation process. Because of the subpoena power, if, for example, if I say that I never made a payment to somebody, he never got that, but I have a bank, then all I have to do is go subpoena the bank, and guess what's going to show up? I won a fraud case that way. $45,000 supposedly never spent. Oh, look what showed up. So I subpoenaed the bank records and the accountant. The accountant's not going to lie because the accountant's not going to lose his license, okay? So it happens all the time. So now this very first point, every document, every memo, every email, every text, every letter, every contract, etc., will be discoverable. Everything that you think is relevant and everything you don't think is relevant. Anything in that time period when that person worked is potentially discoverable. Why? Because the standard isn't what you think is discoverable, it's not what I think it is, it's anything that could potentially even lead to discoverable information, okay? So I'm involved in a fight right now with the other side who asks me the question, why is that relevant? It's not my job to tell you why it's relevant, because I need to know everything around this way so that I can pinpoint on the lie that I know you're telling me, okay? And all my opponents are doing the same thing if they're doing their job, okay? So when you go in and you withhold information, you've lost your lawsuit immediately. Because once you're proven to be a liar on one point, you're proven to be a liar on all points. Okay? Accounting documents and tax documents, they will be heavily scrutinized, and not by, they will bring accountants in there, they'll bring forensic accountants in there, they will bring, they'll bring in JD CPAs, they'll bring in, the larger the company, larger, those types of things happen all the time where, your own accountant didn't see things that they're seeing. The wage payment system must be perfect, even if it's an ADP. So you're like, well, I had ADP, they screwed it up. They didn't get paid X because of this. I had that situation. Well, I relied upon them. And guess what? It was your responsibility. The fact that you third-partied it out to somebody, you still had an obligation. Your office manager, whoever was handling it, had to be watching the books, and they didn't. So guess what? The law doesn't care that you made that kind of a mistake. You now owe. Your managers and employees, past, present, and potentially future, can be deposed and called as witnesses. Your disgruntled workers are your class action lawsuit ready to happen. I'm telling you, if someone leaves your employment and they're in a time period where there's a problem, you're going to see them again. And you're going to see them you're going to see some email that they had I've had emails that were created after the fact. Let me tell you, because they're talking among their friends. Oh, did you quit? Yeah. I always knew that place was bad. Did you hear this? Happens all the time. So you got to be super careful. Now, to that point, controlling your email system matters, right? There's nothing illegal about having the software that has eyes. You just tell your people, look, everything is fair game, and just make sure you're monitoring everything like that. After the fact, you can't. But again, things like Facebook, all their social media things, those are fair game. So if you think there's a problem, that should be part of the job of the person who's dealing with the employee issues, to make sure that you're aware that those things aren't happening. How many times have we told our employees, don't go on social media and do these things that are hurting our company? And how often has that been listened to, right? I mean, if someone's a responsible person, they're not going to do that. If a person is irresponsible, your admonishment isn't going to change anything. And when they're gone, I'm guaranteeing they're going to go to town. And I've had text messages showed up. Oh, we never had did you talk to somebody in the last 3 years? Oh, never. Show up their deposition, page upon page of text. Exactly the very thing I asked about. So it's a thing. Policies, posters, handbooks, those are all scrutinized, okay? Everybody's got to have a poster. Everybody's got that plastic poster that you can get from the state. If you don't have that in your break room or whatever, go get one. They're not expensive. You have to have them. And like I said, there's those basic posters, they do it. Your workers' comp little notice, just staple that on there. It doesn't, make sure that that's done. And then the disciplinary system's got to be neutrally and consistently defined, and also it's got to be carried out. So don't have the progressive disciplinary policies where you say, I'm going to give you 2 warnings and then this and this. That's not necessarily a good thing, okay? Because you're going to be held to that. Do a policy that is something that you can live with, okay? Better to say all of these are going to be immediately terminable offenses, anything else might be terminable, as opposed to saying, the first time you got to go to Joe, and Joe's going to talk to you for 14 times, and then next you got to go to Mary, and Mary's going to do this. You have to comply with those things then, and that's going to be a problem. So like I said, there's different companies have different policies that matter, so just keep that in mind. Now, the thing I wanted to single us out here is this one mistake, okay? You could be the best employer. In fact, most of my employers, when I'm defending them, they're good companies. They care for their employees. They're trying the best they can, but they only got so many hours in a day. And they got families, and they actually would like to go home and actually spend some time with them instead of dealing with, Will's problem over here on Friday. They're like, I just promised my daughter I was going to go to her 4th birthday party, and guess what? I'm going to her 4th birthday party. And it doesn't matter what happened on Friday night, okay? But when you get here, none of that matters. Why didn't you? Oh, you should have been up all night worrying about this particular situation. So the one area that you made a mistake is what's going to be blown up. Okay? If you lose any information, you lost your case. Spoliation means that you get an instruction or you get a ruling that says that it's presumed that you destroy the evidence. If it's presumed you destroy the evidence, that's a form of fraud. You lost your case. Okay, I have more than one case where I had the case hands down won, and I had a client who all of a sudden realized that they had information, or more importantly, through the subpoena process, my opponent found out information and shared it with me for the first time. I don't want to find out for the first time that this information was out there. So what happens? Spoliation claims happen. And honestly, if it's under your control, you cannot defend it. And your case is done, no matter how good your case was. Your investigation's got to be impartial, it's got to be thorough, and the most extreme violation has to be looked at, okay? So you got to get out, if you have a bad situation, if you have anything that was like, so let's take a situation where you have a school and you had that there was a sexual predator. Let's think about the worst thing. You don't say, that person was really good, we never knew. You immediately take that as serious, and you just go in there and you uncover everything. You ask every single employee who worked with them. You have those discussions. You're like, yeah, but if I start getting more people involved, it's going to be a disaster. It's already a disaster. You have to deal with that. What you don't want to do is you don't want to be in the middle of it. You want to hire so usually you'd hire a law firm who would go in there and they would do that. Or you'd hire an independent. There are independent investigation groups that will do the same thing, but you got to kind of separate yourself, and you also will be interviewed, right? And then you have to be candid about what you did or did not know. Hopefully you knew nothing, okay? Okay, so that's the discovery process, kind of a nutshell. Any questions about those? Any questions? Okay. So now liability and settlement. So this first point here, every labor and employment law allows for class action and fee shifting. You will see both. Class action lawsuit is just similarly situated people, okay? And you'll see it in two situations: wage claim disputes, where people aren't being paid, and you'll see it in discrimination and harassment. If it happened to one, it happened to everybody. That's where that thing I was telling you before about the text messages after the fact, it all happens. You might be completely ignorant of it, and hopefully if you are completely ignorant, you'll be protected. But there's always going to be that one person who does this. I told manager so-and-so about it, and they did nothing. And manager so-and-so is like, that person never said it to me ever. But that person's willing to lie for their friend. And that's what you have to be. They said every disgruntled worker, and sometimes not even your disgruntled workers, sometimes, I mean this in a respectful way, but there are people who don't like confrontation, but in the worst possible way. That if their friend comes to them, they will try to help, even though they'll pick the lesser of two evils. They'll say, I don't want to hurt my employer, but I also don't want to hurt this person I worked with. The employer can handle it, the employee can't, and they'll help out, and they'll do damage. And they don't intend to, but they do, okay? So there are attorneys who love to prey on that, so they will look for class action lawsuits, and you can't stop it. You can't say, well, that's not fair that you're notifying all my employees about my bad conduct, or what you say is my bad conduct. They have an absolute right to do that. Fee shifting. You're probably familiar with the contingency fee situation where people they'll take a case on to get like a third. You hear about that in auto accident cases, right? Fee shifting is even worse in employment cases because it means their hourly rate gets assessed against you as the employer. And their hourly rates are never reasonable. Do you know how many attorneys out there that charge $750 to $1,000 an hour? None of them, unless they're employment attorneys, or anybody in a fee shifting thing. And you know what? There are judges that are willing to pay give them $400, $500, $600, $700 an hour to defend the case with 3 lawyers involved, because there's always a team involved in those, okay? So the problem is that when you have these lawsuits, you have this tiny case, but it's a big one. How are we doing? Okay, we got time. All right, so if you have a case and it's only a couple $1,000s, okay, and you're like, I'm going to defend this to the hilt, realize that your $1,000 case is a $100,000 case right out the bat. If it's in a lawyer's hands, unless you end that right away, and you'll be like, well, yeah, I'm going to fight for my good name and all that type of thing. Okay, there's a time and a place to fight for good name, but not you don't spend $100,000 to save your good name for $1,000. Okay, because realize that is a thing and it will happen. Okay, so that's my point here. A small violation leads to a lot of money. Employment, now I want you to focus on how this starts, okay? So for a lot of these cases, start at the agency level. So wage claims will start at the Department of Labor, and if you look at your discrimination cases, they're going to start at the EEOC, which is the federal, the Equal Employment Opportunity Commission, or the Illinois Department of Human Rights. Those two agencies work in tandem. Okay, so when you file suit for discrimination, you actually file with the EEOC and the Illinois Department of Human Rights. They have an option of which of them are going to take it. Usually the EEOC will take the case. They'll assign an investigator. Many of those investigators are actually former defense attorneys, or they work for large companies. So they already have a pro-employer mentality. Surprisingly, it's actually one of the few areas. So when you get an investigator, people say, I'm not going to mediate because I believe in let's just go to court. Never, never do that. You take them up on the mediation. It's usually on a phone call. It could be a conference. Occasionally you got to go downtown, not really anymore. And they'll ask them what's going on. In the mediation, the investigation side, they'll usually educate everybody to the law. Importantly, they'll ask the employee, do you know what the law is? Sometimes they're just dead wrong. I actually had a case, the investigator ended our case that day, took the employee aside and said, what they're saying is this, do you understand that? Yeah, I do, but I was wrong. Do you understand that's not wrong under the law? The case was dismissed, voluntarily dismissed. Okay, it doesn't happen that way often, but that's how important that is. As opposed to the situation in other cases where people are like, I'm not going to go forward with that. They can sue me if they want, and then they do sue, and then you forfeit that opportunity. Because now an attorney has it in their hands and they want their money. And they're not going to settle for $500, even though the employee might have just won a couple thousand to move on with life. Okay?
What percentage of mediations actually end successfully where they don't go to court?
Pretty good in the employment setting. Pretty much. I would say that in the wage and in the discrimination ones, if I've ever gone before the state agency, they will, because they're specialized. That's the important thing in the agencies. That's all they do all day long. So no one can actually mislead them in the law because they know it. In fact, you look foolish when you do so. So they want to resolve their cases because their loads are so heavy. I mean, to say that there's a 3-year backlog is not an understatement. I mean, they don't want to handle the cases because they know of 1,000 cases, there's probably 100 good ones. Okay, so what they'll do is they'll try to get you in, and they really want you to do it. The mediation process is free. So you might as well take advantage of it from the investigator standpoint. What's the worst that happens? The investigator says, you can't get it resolved. The investigator will then do a mini hearing in which they'll ask questions of both sides. Has everybody been through like an unemployment hearing? Okay, so you know how that goes. The employment ones for like discrimination, they kind of go the same route. They'll ask those kind of questions, but it's more drawn out. It might be a couple hours instead of the half hour that it's supposed to be. But it's the same thing. So what happens at the end of those is that they're trying to get rid of their cases. Now, if it's egregious, if you look at this last point, they'll take the case, but hardly ever. It would have to be beyond egregious. In fact, I had a fact pattern that was, the facts could not have happened this way without the lack of video that they said, but imagine that, the worst that you could think. Even that case, the state was like, yeah, we're not interested. Why? Because they've heard it all. When they see a fact pattern that crazy, they're like, it might have been, but we're not going to waste our resources. I'm sure there's some attorney out there who will handle it, So what they're looking for is the real one. So let's say, for example, I sue and I say there's race discrimination going on in my place of employment. And it's established. I got 2 or 3 people that are all going to say, yeah, we all got fired, or we're making, like $4 an hour less than the other person. They would take those cases because those are clear violations. But the situation where the person says, because of my race I was fired, and the employer says they were a poor performer, the state's not interested in that case because that's what everybody says, right? You got to have a basis for your lawsuit. So they say, we're not going to take it. They give you what's called a right to sue. And so the right to sue is basically you have 90 days to file suit on it. And if you do file suit on it, you do. If you don't, you don't. So they're going to file suit, right? If you get the right to sue letter, there's always an attorney in the background ready to take the case. And they're going to the fee shifting, okay?
Thank you again for watching this informative session. If you have any questions about what you just heard or want to contact us for legal or business consulting services, you can reach us at 630-230-8434 or email us at kmclaughlin@ma-lawpc.com. Have a wonderful day.